We've got Charles Smith, who's the retirement practice leader in Nebraska, and he is an attorney who spent the last 20 years working retirement plans, first as an ERISA attorney, then in-house counsel for record keeper. Now he's a senior advisor here with Qualified Plan Advisors. We have Matthew Eichmann as our national practice leader for Qualified Plan Advisors and a member of the firm's investment advisory team and counsel. Matthew has more than 16 years of private practice focused on employee benefits, and he's also a frequent retirement speaker on retirement matters. And then we got Scott Lickett, who's been working as an attorney for over 25 years of financial services and retirement plan legal experience. Scott graduated from the University of Nebraska School of Law. And finally, Mike Smoots, he's a licensed attorney for over 20 years and previously served as the vice president of one of the nation's largest record keepers. He graduated from K-State in 1992 and KU Law in 1997. So thank you guys all for joining us as usual on our semi-annual ERISA talk. Today, we're going to be talking about the Secure Act 2.0, which was signed into law in December of 2022. Now, the session is designed to try to help you sort of put some of these new provisions into context, and we'll kind of help you guys decide whether maybe or not whether it's right for your company plan. We are still waiting for guidance from the regulators on so much of what we're going to talk about today. So it is very much just more of a framework for you to consider what you might want to do. But for those who've joined us before, I think you're going to find this is a little bit different today. We're going to do things in much more of an sort of an open session format instead of the normal, more scripted presentation that you do see. And I hope you guys will like it. I think you're going to really like the sort of the give and take of how we're going to present today. With that, I want to start off with the first topic and really our roadmap for today, as you can see on the slide here. You can see we'll talk first of all about required minimum distributions. We'll get into automatic enrollment and escalation, Roth employer contributions, which was a big debate there, matching student loan debt repayments, emergency savings accounts is in the agenda, catch-up contributions and the changes there, coverage of long-term part-time employees and the savers match, lump sum cash outs, and there's even more that we're going to talk about in detail. So I hope you guys find this useful. With that, I'm going to kick it off with Scott and Chuck to give us some insights on required minimum distributions.
Well, thanks, Rob, and thank you, everybody, for joining. And I want to circle back to something Rob mentioned. And when we were getting ready for this call, Matthew Eichmann, being our national practice leader, has been in the middle of many conversations, many meetings, and just kind of, I want him to update us sort of where the status of all of these new rules are coming and what to expect going forward. And I think he has a very interesting perspective, if you could share that with us, Matthew.
Yeah, thanks, Scott. Appreciate it. And then I think, Rob mentioned we're awaiting guidance on a lot of these topics. And then just a follow-up comment on that, we had a series of meetings with folks with the IRS and the Treasury and the Department of Labor here about 2.5 weeks ago. And what was interesting about those conversations is that when we have those talks, we customarily reach out to the government and say, what are the things that you want to talk about? What are the things that you want to tell the audience about? And in this situation, the regulators said, hey, we have a few things that we want to tell you. We're actually most interested right now in sitting and listening, and we want to hear from practitioners and from the public regarding the open questions that they see relating to Secure 2.0. And what they said essentially is, we at the governmental level plan to issue later this year a grab bag of guidance that will help to answer a bunch of questions. But what we need you to tell us is, what are the big open questions? What are the things that people are really struggling with and they don't quite know how to answer those questions? And so today, Scott, as we start working through these questions, we're going to identify those questions. I think we're going to have some pretty good answers, and where appropriate, we'll point out where that additional governmental guidance will come in. So thanks for the opportunity to share that context. And I think this is a natural time for me to flip this question right over to you. So Scott, I'm hearing, there's a change to the RMD age. It's now 73. So, maybe you and Chuck can kind of talk us through how that's going to work in 2023.
Absolutely. And, thanks for the opportunity. And this is one of the provisions that's effective now. As we go through the materials, you'll see there's different timelines for effective dates of a lot of the provisions we're going to be speaking to today. But the raising of the RMD, the required minimum distribution age limit, is effective this year. And if you look at the timeline at the top of this slide, you kind of get a little bit of perspective. For over 40 years, the RMD age began at 70 and a half, that quirky 70 and a half figure. And that's the way it was for over 40 years. Then recently, there's been quite a bit of change in a short period of time. With Secure Act, the first one, 1.0, it raised it from 70.5 to 72. And now with 2.0, we've increased it another year. And I think it's, so it's important to kind of have that as a backdrop and keep in mind, you really have two groups you need to think about. Because what required minimum distributions are having a participant start pulling money out of their retirement savings, primarily to start paying taxes on it, because generally speaking, for many decades now, it's been focused on, pre-tax savings. So you've got people that terminate, separate from service. They need to start pulling their money out. They'll probably still could be a participant in the plan, even though they've terminated. So you have that group. And then you also have a special 5% owner rule, because if someone hits this age and they're still working for you and they're still an active participant in your plan, they don't have to turn on the RMDs. But if they're an owner, 5% owner or more, they will, even if they are working. I think that's an important distinction. So you have two different buckets to think about. And so beginning now this year, you don't have to start that until you turn 73. So if you were 72, if you turned 72 last year, on or before December 31st, the age 72 impacts you. Now, Chuck and I want to talk about just some, practice tips and things to think about. As I mentioned, you really need to look at your group as two different groups. If you have, 5% owners by chance, and your terminated participants. And so it probably is also a good idea to look at, looking forward, what is your demographics of your group, who's going to start hitting this new benchmark of 73, and kind of go from there. What's your thoughts, Chuck?
Well, Scott, actually, I'll turn it back to you with another question. You mentioned targeting and looking at those individuals, especially those who turned 72 this year and would have received an RMD, but do not need to now. Is that burden falling on the plan administrator, the plan sponsor, or are you seeing that more as a record-keeping function, and they're going to kind of alert the plan sponsors this year how to operate with that?
That's a great question, and you really do rely on your record keeper and TPA. Each group's a little bit different. And what I've found over the years is this is a good opportunity to revisit. What is your record keeper and or your TPA's procedures and processes for RMDs? Now, depending on the age of your group, this may not come up very often. Alternatively, you may have a lot of people that this impacts. And it's always a good opportunity to have a better understanding. What's the timeline? Because record keepers, while they get to the same end result, they have different approaches, different processes, different timelines. And so this is a good opportunity to, get an understanding of that. And also, if you want to, help your 5% owners, you might want to be thinking ahead for them. Who's going to start hitting, who's going to be turning 73, et cetera. And I think that'll go a long ways to help you be proactive in this area.
Yeah, and one other thing I'd like to point out about the RMD rules this year is they've now paired retirement plans with IRAs with respect to the treatment of the Roth contributions. In years past, unlike IRAs, an RMD had to be taken from both pre-tax and Roth. But going forward, it is just from the pre-tax contributions and not the Roth, which will mirror if anyone's had a Roth IRA, they do not have to take an RMD distribution. So this may be an opportunity for some participants who are already taking RMDs, that their amount may be less, and just as a plan sponsor to be aware of that. And it also may be a way to encourage participants to stay in the plan, because previously you had to roll those Roth amounts out to not be subject to the RMD rules, but now they can be kept inside the plan.
But before we get off this topic, let me ask you a question, Chuck. What, for plan sponsors that are sitting there going, okay, great, this is a change. What do I need to do for my plan doc? What is there anything I need to do as the plan sponsor?
Nothing today. Just like with the Secure Act 1.0 that was adopted in 2019, there will be an amendment to your plan document, but we're years away from that. I believe that's 2025 when that will become effective, and you'll work with typically your record keeper if they're providing your document, or if not, your individual plan designer. They would craft that amendment to you, but you can still operate under these new rules. prior to that official documentation with your document provider.
Okay. With that, I think we'll hand it back to Rob and Matthew as we keep moving forward.
You know, the really next question we're getting is, you know, what's going to happen now with automatic enrollment? Are automatic enrollment and automatic LSation now required in all plans? Is it certain plans? And, you know, I think I'm going to ask Matthew to kind of address that question straight up and really kind of guide us through this new provision.
Yeah, thanks, Rob. And it's really interesting. I think that this is one of the aspects of the new law that's created more initial confusion, but we can settle that down pretty quickly. So Secure 2.0 is going to require automatic enrollment and automatic escalation for new plans. And these new plans are going to be those that are established after the day that Secure 2.0 became law, which was December 29th, 2022. And there's actually a period of time, though, before that requirement kicks in. That'll be in 2025. So just for all of you out there who are already working with your plans, and maybe you have automatic enrollment, maybe you don't, maybe you have automatic escalation, maybe you don't, just understand that this doesn't have any direct impact on you. This is not a new requirement. It's going to require you to do something that you're not already doing. So I think that's a positive for everybody who's saying like, uh-oh, what will we have to do? Well, this is not one of those things that you will have to do. But Chuck, I know you and I've talked about this a little bit. We think that over time, this is going to change the landscape of retirement plans to a degree. And, you know, I know you've got some thoughts on kind of how that might happen and what impact that might have.
Yeah, I agree with you completely. You know, when this was first passed, I think we put this on our list of things not to talk about because we already have, our clients already have a retirement plan. They're going to be grandfathered from this. But I think this really serves as a warning sign for existing plans, just huge blinking light about what the opinion of the IRS is, what the opinion of Congress is, and really where the future of retirement plans are going. If you don't have automatic enrollment right now, you're soon going to find yourself in the minority if you're not already. And if you're auto enrolling, but at something less than 10%, which is what the new requirement is going to be, auto enroll or auto escalate up to somewhere between 10 and 15%. You might want to start looking at that and revisiting and thinking about, you're probably not behind yet if you're at 4, 5, 6%, but I think eventually you will be. I know the hesitation has been really that there's going to be a backlash from participants, employees, that, oh, you're forcing me into the plan. First we did 3%, then we went up to 6%. But I think that the tide has turned. I think, especially with this new act and requiring it for all new plans, employees are going to expect this. And they're actually going to be surprised if you don't have automatic enrollment. And I think this is a good thing. I think this is the the defined benefiting of the retirement plan space, where we enroll people at a level, with a 10% auto enroll, plus you give a 3 or 4% employer contribution, and now they've got enough going into that plan. Pair that with your qualified default investment alternative, your QDI investment, that they can just come in, start working, and they're on their way to a healthy retirement through that retirement plan.
Yeah, so Chuck, if I were keeping notes from our conversation today, what I would write down from this is not a requirement, but if we don't have it, it's something we absolutely need to be looking more closely at.
Absolutely.
Next, there's a lot of talk about Roth and the Rothification that occurred under this law. And so I'm going to pose this back again to Matthew and Mike, really, but one of the great provisions, or at least one of the ones that I kind of like, is Roth employer contributions. But how is this going to work now? Is this something that's required? Can you guys talk a little bit more about how this Rothification specifically affects the employer side of the equation, the employer funding?
Yeah, I'll take that first part of that. And then Mike, I'm interested in getting some of your thoughts as well. I think it's important for us to recognize this new Roth employer contribution feature as being optional at 2 distinct levels. So first of all, it's optional at the employer level. A plan sponsor, each and every one of you can decide whether you would want to make this available to your participants. And then if you do, each and every participant then would have the option of deciding whether he or she wanted to put all or perhaps a portion, and that's yet to be determined, of the employer contributions into that Roth bucket. So I think that's helpful. Again, one of these issues that a lot of people heard, like, oh, all employer contributions will now be Roth. No, that's absolutely not the case. But there will be this option available as we move forward. And, Mike, one of the open questions that we have on this relates to the language within Secure 2.0, and it says that if you allow this, those amounts must be fully vested. Well, that's given rise to a lot of questions. So does that mean that if we have a vesting schedule in place, that we have to wait until somebody is fully vested before we would give them this option? Or does it instead mean that without regard to what the vesting schedule otherwise would be, if the employee makes a selection and therefore the employer match gets put in on a Roth basis, that it's immediately and fully vested? We're waiting for governmental guidance on that. I think the answer will be probably closer to the latter. But Rob, I know that you've got some ideas around what employers might do to kind of handle this within the plan document. Mike, I know you've got some additional thoughts from a practical perspective. So I'm gonna throw it back to both of you and just kind of hear your thoughts on this.
First of all, I really do like this provision. And I think it's great that if you're interested in providing this option, giving employees the ability to do it. Again, highlighting again that it is indeed certainly optional, but one of that, again, as far as the vesting is concerned, I too, that was the first thing I was concerned about is how, you want to make sure that this is vested, and can you perhaps just say, okay, we're only going to allow it once a person is fully vested, and then you don't have any such issue. But can you do that? I'd like to get the regulator's thoughts on that. Does that create any compliance issue too if you try to do it that way, or is there a benefit right or feature issue that kind of kicks over that hasn't been thought about, which is why I think it's so critical to get regulators to just opine and say, here, this is the best practice of how to handle it. What do you think, Mike?
Can you hear me?
I said, yeah.
So Rob, on that, I don't have an opinion to share that I think is point of any experience or context or discussion so far. I do want to add this point. I've had a couple of plan sponsors ask me the question of why would we do this? And, does it make sense? And in two cases, it was kind of an odd question because they both were under the impression that if they changed their company contribution to Roth to add this feature, all of a sudden they would lose the deduction on their taxes for making the company contribution. We've talked about that, batted that around among this group, even sought counsel from a CPA. There's no reason to believe that the definition or the treatment of comp under the tax code is going to change with the addition of this feature. So I wanted to make sure that we got that out there. I've kind of heard that rolled around a couple times. I think it's a little bit of a misnomer. Matthew or Rob or even Chuck, we talked about it. I don't know if you want to comment on that or not.
I mean, from my perspective, think of it this way, and you and I talked about this offline. There was a time for those of us who are old enough to remember, but before I think it was after the Small Business Jobs Act, but I think it was an EGTRA, where we actually, if you read into the details of the code, an employee deferral salary deferral used to be considered an employer contribution, and only after true thrift contributions were considered employee deferrals, and they changed that. And that confused people. It's like, well, is that going to be deductible anymore? And the answer was, well, it's still comp. The employer paid compensation to an employee, and the compensation is deductible the moment I pay the employee, regardless in the format in which it gets paid out or the character in which it's done. So if I'm paying an employee W-2 wages, I take that as a deduction, even though it's taxable to them. So to me, it may change the geography of how you account for it, but it doesn't change its deductibility.
Yeah, and so I think, I echo your thoughts, Rob. There are a number of open questions about how these will work. And what's interesting is this is actually available now under the Secure Act, Secure 2.0, but it's practically not available anywhere because of all these logistical things we've got to work out. We've got to figure out how we handle things from a payroll programming perspective and figure out whether the record keepers are going to say that an employee makes an all or nothing election, for example. Must that employee decide whether to put the entire employer matching contribution, or can he or she elect to put half in Roth and half pre-tax? And then if they do you as an employer even want that sort of complexity? And then finally, we don't even yet know whether these amounts, which remember, they're going to be subject to tax now, will they show up on a 1099 or will they show up on a Form W-2? So we're going to get a lot more guidance. I mean, this is effective and technically available now. This will be front and center in the guidance that we receive later this summer. So I think we'll stay on the lookout for guidance on that, Rob. And then I think that's a good time for us to transition to this next topic.
Yeah, no, and this is another really popular topic, talking about matching when it applies to student loan debt payments. This has been something that, a lot of people have been looking for ways to help employees with student debt. And so when do we have to start matching student loan debt payments? How do we do this? Like, what is this even going to look like? Mike, I'll kind of pose that question to you. What are initial thoughts on this?
Yeah, thanks, Rob. So the first aspect of this is it's optional. You do not have to do this. The second aspect is it will not be available until next year. And so as Matthew has sort of alluded to here several times, you want to be talking with your counsel about what does this look like? What are the implications from compliance, testing perspective, et cetera. And then also you want to be closely coordinated with the record keeper because they're going to have to spin up their IT teams, right, to make this available. So the first point is it's optional. We'll see, various record keepers may have staggered timelines for implementation. But the purpose of the rule, the change in the law, is to allow an employer, particularly one that may have a number of young workers that have a heavy student debt load, it will allow that employer to adopt a feature that says, if you make a payment against your student loan, we can match those payments in the retirement plan. There's an issue about, what does that look like? How are we going to be sure that the payments were made, et cetera? Does it qualify? So far from the law, it looks like that the student or the employee will be able to self-certify. So that should give some comfort to plan sponsors, but, and Matthew, please interrupt me here. We don't really necessarily know how comprehensive that's going to be in terms of plan sponsor can absolutely totally rely on the self-certification from the employee that the payment was made. I think that's kind of what I've got there, Rob.
Yeah, you see, I think matching student loan debt payments, I think trying to help employees in general with student loan debt is a big issue, and it's a good issue, and we know that so many people, and they don't have to just be former students themselves. There's plenty of Gen Xers that have kids that they're paying student loan debt on that is quite suffocating. So it's a problem. If I was just taking a step back as an HR professional, as a benefits professional, and saying, what do we need to do to attract Gen Y and Gen Z talent? Doing something with student loan debt is going to attract, a talent. I think the question you have to ask yourself, is this something I want to do inside my ERISA retirement plan? Do I want to have a policy outside of it? There's a lot of ways that this can be done, okay? And try to get a sense of whatever you're doing, are you helping employees the best way you can that will attract your employees? And that's the policy you want to set. Maybe it's inside the 401k plan or 403b plan. Maybe it's not, okay? But thinking of something you can do to help employees with their student loan debt is going to attract talent, and it's going to retain talent too.
Yeah, when we talked about this, I'm sorry to call Chuck out, but there were some comments, whether he'll own them or not, or I fairly attribute them or not, that does this make sense to do this inside of an ERISA plan? Because once you put yourself under that sort of regulatory scheme, you've got to comply with all the rules, and it might be, just a straight on bonus for student debt. If it's dedicated to that, makes more sense.
So you brought me to this. So what do you guys see what type of employer would you see utilizing this type of provision? Is there any type of industry or profile of employees that an employer, a plan sponsor on this call might think, oh yeah, that fits me versus others?
Chuck, I'll jump in that one right away. Very clearly from our perspective in the medical industry, I know it's really easy to assume that physicians, make a lot of money from the start, but even if they do, their student loan debt's frequently pretty significant. And so the number of young physicians or others working within the medical industry who've had to undertake and experience so much schooling, they're in this either or situation. And what they find is they either have to pay down more aggressively on their debt, potentially at high interest rates, or they put money into the 401k plan so that they can capture a match. And in our experience is a lot of these medical companies are going to say, hey, let's do this so that our employees can pay down their debt aggressively if they want to, but at the same time start to build that nest egg within the 401k plan. So that'd be a starting point. I think many of you can probably envision other, fields, maybe, legal, anything that involves some sort of graduate school in particular, where you've got additional student loans. I know that's one thing. Mike, what are your thoughts on that?
Yeah, I think professional services firms, frankly, and I don't want to go into a rabbit hole here, but most of the plan sponsors that I've had a conversation with, when you start to kind of pull back the cover on this and understand what qualifies for repayment, it can get kind of dicey. And Chuck's point about do you want that under ERISA or not? I think if you're at a professional services firm, medical firm, it's likely the cost benefit analysis may weigh in favor of it. If you're at a traditional sort of operating company, there might be a better way to achieve the same goal.
Okay, with that, I think let's, go ahead.
Rob, and maybe to Chuck's question too, I had an interesting experience with a client earlier this week where I walked in thinking that our conversation would lead us right down this path. And as we talked more about a current student loan debt related benefit that they make available to all of their employees, they mentioned that right now have only 3 employees in the entire organization who are taking advantage of it. And 2 of those are already capturing the entire match within the 401k plan. So under their current situation, if they were to add this to the plan, it actually would, in theory, only benefit 1 of their people. And they say, ooh, the juice isn't worth the squeeze there, right? So I think it'll be interesting to see as employers maybe start to do some surveys as a result of this. We can talk about during the wrap up, but this is one of those where I really think it'll be helpful for an employer to try to gauge the level of interest from its employee base before moving forward.
Sure, agreed. In somewhat of a similar vein, believe it or not, because they're very different concepts, but in reality, how you service them, I think, is going to be somewhat similar. But one of the great provisions of the program is in-plan emergency savings, okay, and trying to create employee savings. We know that there's a savings problem in this country in general. More than 50% of Americans will tell you they don't have $1,000 saved up. And I recently read a survey where you've got roughly 78% of Americans say they're living paycheck to paycheck. So creating something, to help them is probably a good idea. But again, how is the in-plan emergency savings provision going to function? And with that, I'm gonna pivot over to Chuck a little bit to kind of sort of lead this discussion and give us some thoughts on how he thinks you might want to consider approaching this relative to what the Secure Act does.
Yeah, and I'll take a minute or two to give some background on this. I think this one's a little bit more confusing from an operational standpoint than some of the others that we talk where we're more about the philosophy of how would this be implemented. But the emergency savings account, it's a new type of account that is optional for retirement plan sponsors beginning in 2024. And how I think of it is it's another form of a Roth contribution with a different investment vehicle. And what I mean by that is it's an account that you can set up for participants, employees. Contributions will go into this emergency savings account up to $2,500. And it must be, unlike the normal mutual fund lineup that you've got, it has to be invested in a interest-bearing savings account, essentially. So we're talking, in today's market, it's basically going to be static. But one of the advantages of it, well, one is it can't lose money. It's a savings account. It's going to be invested in an interest-bearing account. And 2, it has these special distribution rules where participants can take 4 withdrawals per year without fees. Now, that's going to cause an issue and I'm going to turn it over to you guys here in a second, but how do we process that? How do record keepers who normally charge $50, $60, $70 for a distribution, they're going to be required to process these distributions for free, or are they going to charge it back to the employer? But it's an attempt to give employees who may not otherwise participate in the retirement plan because they're concerned about other finances and need to access to cash, to be able to put them in the retirement plan, still get any matching contribution that would be made on a typical Roth contribution, but then allow them to withdraw it if they need it. And unlike a hardship distribution where it has to be set up for a specific number of reasons, or unlike a loan where you typically have a loan processing fee, this would be an easy way for participants to access their account. There are going to be some difficulties, right, from a participants or from a record keeping standpoint. This may take a while to get up to date. I know it's effective 2024, but you can just start to imagine all the logistics that have to go on in the background to be able to take Roth contributions up to a certain amount. If someone elects to go into this certain account, up to $2,500, and then no further contributions can go to that account until the person takes a withdrawal and brings it back down under $2,500. And then monitoring distributions. So, I mean, when I'm talking to plan sponsors about this, they have to look at themselves, I think, and say, one, do we have a firm handle on our record keeping and our retirement plan where we're good about processing distributions? They just operate like clockwork and we can handle this additional work. Is our record keeper, are they handling distributions well? What is our experience with them with complex administration? Will they be able to handle this? So I see a lot of things up front that give me cause for concern, but I'm going to turn over to you and Matthew maybe to opine on kind of your thoughts on whether this would be a good benefit for plan sponsors.
Rob, go ahead.
Look, anything we can do to help employees who are not, who are in this financial issue is going to lower their stress level, and it's going to make them better employees, and it really is, and we've talked about this from a financial wellness perspective, is just getting people to live in a budget and have money available for emergencies is going to take some of that stress off their shoulders. So having some way for them to save in an emergency, for emergencies is a great idea. Is this the most effective way to do it? That's I don't, do we need to put it inside an ERISA plan? I think there's a lot of options that you have that don't require that. Some of my clients are banks. I can't imagine them wanting to do that when they can encourage their employees to make deposits at the bank. And I had a very prescient client of mine. I'm hoping she's listening today because I was listening too. She's like, why is this any different than the account that they're already depositing their paycheck to? And I said, you know what, you're right. In a manner of speaking, it's a matter of geography, right? Again, putting it in a separate place is something for a mindset of employees, but creating that separate, encouraging place, I think, is really all we're trying to do. Is saying, okay, let's have your savings in one place and your checking another. It could be at the same bank, but in a separate account might encourage you to save it. So I don't know what your thoughts are, Matthew.
Rob, I get questions. People say, why would we do this? Why don't we just have them set up a savings account? And I say there's three real clear reasons for me. Number one is it happens through payroll deduction. So it changes the geography. It routes it into a specific place and you can do it through payroll deduction. That's great. Number two, it can be subject to the match within the plan. So if we tell our people to go set up a small savings account at a credit union or a bank, it's not going to be subject to the match. We keep it in the plan, it can. And then third, puts them in a position where every time they log onto their account, they'll be able to look on their app or on the website. They're going to see this. They'll know it's there. And I think this is as big of a psychological benefit as it is intended to be a financial benefit. To me, this is a wellness play. So when I think about what employers might want this, are you a wellness-focused employer? I think it might fit there. Chuck brings up good examples of where maybe it's not the right fit. Maybe it's more work than it's worth. Or to your point, Rob, for banking clients, probably not a great place. They've got other options for their people to save their money. But I think for companies who are really interested in wellness, this will be something that a lot of people are interested in.
And Matthew, you and I have talked about this, and I like the one reason you missed, a fourth reason to implement this, and that is they've always had the ability to put it into a savings account, and no employers are doing it. It isn't working.
Right.
So let's try something new.
It's funny too. I'm monitoring the questions here, and somebody just said, "Hey, the ESA seems like a good offering to potentially include as an optional benefit. How would you anticipate the interest in this would compare to that of a traditional savings account?" You guys have some thoughts there?
I think what's really great about this. Go ahead, Chuck.
Go ahead, Matt.
No, I do think that, especially in plans that have active financial wellness programs, especially, I think it's going to get a lot more uptake than you'd ever imagine. I mean, I know that we talked to John Poole about does all of our education, and it makes it easier for him when he can say, look, there's a program set up for you to save in when we're talking about budgeting. And it really makes it easier for him to help them say, okay, you should go. It's much easier for him to say, hey, you should go save in this program, and here's how you do it. And he can even walk them through it than saying, hey, as part of your budget, make sure you save $100 a month. he can actually walk them through a way to do it. And if you've arranged for that, I do think there's going to be a lot of adoption. And I think people are going to be very, very excited about the concept of an employer setting up an easy way, payroll deduction way of making money, of saving money for it.
And I would throw in the fact that it automatically switches once someone hits $2,500. It automatically switches. They've got enough there. Let's move that to a traditional Roth. Well, if you set up a separate savings account, there's no one's checking that, and you may never. We know John Poole, when he talks to employees, getting them to say, "Oh, that's enough. I need to move it back to the 401k." And then when you have an expense, okay, now when you shift my money back to that savings account, this kind of takes care of that for you. If you've got a good record keeper who can do this seamlessly.
Yeah, no, it is a great way to in a way, if you're having low participation too, because people aren't saving enough, it's kind of a way to backdoor participation. Because like you said, once they hit that $25 limit, they get into the 401k plan, they get the match. It does increase participation in sort of in an indirect way.
Well, and we haven't even talked about the fact that the new law does allow automatic enrollment into this. So there is the ability to enroll up to 3%. And so there are some employers who are thinking about kind of a split or a double automatic enrollment, if you will, where say you auto enroll 4% into pre-tax and 2% here. And then when you hit that limit, as Chuck just described, it would flip over and go into a pre-tax account. Again, there's some logistics there and some communication issues to work out, but there are some opportunities to be creative as well.
And you have to think about, let's say their emergency savings drops below $2,500 because they made an expense. Are you going to flip it back to emergency savings again from the 401k? So there's a bit of payroll work to do.
Yeah.
Okay.
Good debate, guys. Oh, go ahead, Scott.
I was going to say, Mike and I want to share with you some thoughts and perspectives on a couple of provisions now. And as Rob's highlighted here, there are going to be higher catch-up contributions in the future. And then there's the Roth aspect of it. And I'm going to start with, we're going to look at two different provisions here, effective in 2 different years. And I want to start with probably the more straightforward one, and that is really continuance. I think some of you are probably, picking up on or observing a lot of the things we're talking about today is Congress's attempt on increasing opportunities for people to save for retirement and or just flat out savings. We just talked about emergency savings. We talked earlier about opportunities to count a student loan payment as a deferral. So additional expansion of opportunities for people to save. Here we've got the first one I'm going to talk about is the enhanced catch-up contributions, and it's a unique carve-out. The rule up until 2025 is pretty straightforward, which is, all right, if you are 50 or over, you get to make an additional $7,500 annual catch-up contribution, right? Pretty straightforward. Well, there's a carve-out beginning in 2025 for those ages 60, 61, 62, 63, all right? And they're going to be able to make an additional, above and beyond the $7,500 to $10,000 or 150% of whatever the 2024 limit, which won't be announced till the end of this year. But so you have this unique carve out for this age band, all right? So that's the first aspect. And as we note down below, it's pretty straightforward, even though, there's going to be some payroll issues. I also would suggest that people start thinking about, all right, this doesn't take effect for 2 years. So who in your participant group is going to, either be moving into this age band or moving out possibly, because they are now going to have, at that time when it becomes effective, they're going to have an additional opportunity to make a larger catch-up contribution. And the second aspect of this, which actually becomes more effective sooner. We talked about 2025, but in 2024, next year, and this is again somewhat unique compared to the other provisions we've talked about. It is that beginning next year, all catch-up contributions must be Roth, and I want to emphasize the must. We've talked up until now about all these provisions primarily being driven. RMD's in effect now, which we started with, and there's certain things that are applicable now. But most things we've talked about, it's a total option. But now this has got the magic language must. So catch-up contributions beginning next year must be made in Roth if the wages are 145,000 or more based on prior year. And as Mike's going to touch on, add some perspective, that there's a lot of issues in just that, short paragraph there.
Yeah, I think the interesting point here is the must. And so you can't have catch-up contributions unless they're made in Roth dollars, and then there's a carve-out or an exception if you're under $145,000. I think to touch upon 2 points that were already brought up, it's interesting in that you won't have to take RMDs from these Roth, just these Roth contributions. So that's helpful, making that synced up with the IRA rules as they've been. As Matthew's already alluded to here, we're going to need some guidance. The 60 through 63 is a little bit of a, we talked about this, Chuck, is a little bit of a kind of a give or take. They couldn't necessarily afford to make the other age groups available. They offset it with the requirement that the HCE folks make their catch-up contribution in Roth, trying to make it budget neutral. But otherwise, we're going to have some guidance, as Matthew's alluded to here, on what the IRS is going to allow on the definition of wages. We're going to look at the previous year's wages, et cetera. So I think we're pressed on time. I'll leave it at that.
I would like to briefly emphasize one point. If you have a plan that is not a safe harbor plan, and you currently have to go through your testing each year, if you're on that borderline where maybe you failed the first time through, you may be familiar with the situation where then employees' contributions are recharacterized as catch-up contributions in order to artificially lower your testing data. If you're in that bucket, this should give you some pause and cause you to wonder, wait, how do we handle that if we recharacterize it and then it becomes Roth, and how does that work from a tax reporting perspective? I know that sounds like I'm in the weeds, but if you're in that world where you don't have a safe harbor plan you're testing, this is a big thing for us to focus on, and it's going to become important starting next year. So I'll throw it back to you, Rob.
No, it's a good one. I actually had not thought about that one, so I thank you for actually opening my eyes to that one, honestly. Now we're going to talk really quick with Chuck and Scott on sort of a retcon of the new long-term part-time rules, which are really an amendment to Secure 1.0. And I'll kick it off to Chuck. How does Secure Act modify this?
Yeah, so if you recall 6 months ago when we did the ERISA training talk, this is what I spoke on, and we knew this was coming down the pike, but now it's implemented. And it really, the crux of it is it changes the time period that used to be if someone was a part-time employee, meaning there were 500 hours in 3 consecutive years, they had to be allowed in for salary deferral contributions. They've lowered it to 2 years and included 403B plans, ERISA 403B plans into this. So just be aware that's the new rule. The practical tip is the same thing I said 6 months ago. This is if you're not going to avoid it, you can make sure your record keeper has good data so that they, even if you don't think a participant is eligible, give them their hours, give them all your sensitive data so they can be alerted to whether someone would be applicable for this. Or 2, talk to the advisor on your plan about allowing participants into the plan just for salary deferral. Doesn't mean they have to get a match or a profit sharing, but just so that you can avoid tracking, utilize this. Couple of caveats on that. If you're a top-heavy plan, you might want to watch out. There are some requirements around top-heavy. Some of that needs to be fleshed out. And 2, there's a new 5,500 rule that says you only count the number of participants who have an account in your plan as opposed to eligible. So this may increase the number of participants, or you had a chance to reduce that for your 5,500, whether you're subject to a large plan audit. You may be bringing people in the plan prematurely by allowing early eligibility, but it's something to consider to avoid having to track the hours requirement.
And all I'd add to that is,
I'll just jump. Go ahead.
I was going to add to Chuck's comment is what he said. I would emphasize his comment about an employer is not going to be required to match on this classification of deferrals. And the tracking, we can't overemphasize that enough, because while, in my tenure over the years, most part-time employees don't come to work for you to get the retirement plan. But again, this has to be offered. So we have to pay attention to it. We have to get a better understanding of the processes, the procedures. And again, as Chuck Chuck pointed out, there's a lot of good approaches to that, including sharing your data.
Next, we've got a few more things and stuff that's coming up in the future years. Okay, there are a lot of things. Honestly, I know I'm going to start with Chuck to talk a little bit about the the savers match, and then Mike, I'm going to ask you to briefly talk about lump sum cash outs, and then Matthew, if you'd close it up with any other miscellaneous things you've got.
Yeah. So with the savers credit, I won't spend a lot of time on this. Right now, your employees have the ability to get a credit on their taxes if their income is below a certain level. Right now, it's $36,500. This law already exists. The change in 2026 is that instead of being a credit on their tax return, the government is going to give them a matching contribution to some type of account. It could be your retirement plan. It could be an IRA. My practical tip, when this comes and your record keeper asks, hey, where do you want these savers credit matches to go? You have the option to say no. And you don't want the complexity of tracking these and putting them in your account and having distribution restrictions. So think long and hard about allowing these employees to put it in there versus moving it to their own IRA, creating an IRA for themselves. That's my takeaway from this new edition.
Cash outs.
Mike, what are your go ahead.
So in 2024, the number jumps to 7,000. I'm trying to make this quick. Chuck mentioned the part-timers and folks coming in early, Scott and him both. So I think it's also important to note here that the counting rules change relative to how many participants you have. And so you may be able to get below that large plan filer if you're only counting folks that have an account balance. The $7,000 will be a nice feature, and it's important because those small account balances can be a bit of an administrative nightmare. Probably best to get those accounts swept out of the plan.
Yeah, and Rob, there's 4 items listed here. Roth 401k are exempt from RMD requirements, so now that's more like a Roth IRA. That's effective now. There's hardship self-certification rules. It's actually not a big change from what you've probably been doing, but now we have more legal guidance to support it. There will be ongoing increased access to lifetime income. Secure 2.0 does some things to make QLACs a little bit more appealing, and also just to make it easier in general to offer in-plan annuities. And then finally, there's a lot of interest in this ability to convert 529 counts into Roth IRA, and that's kind of its own webinar in and of itself because it looks really appealing and up front, and frankly there's so many strings attached to it that we're not going to see it used nearly as much as people thought at first. So we'll throw it back to you, Rob, to wrap us up.
No, this is, first of all, it's been a great job, guys. I really like the give and take here. I think it's wonderful. We're going to want to make sure that we make everybody aware, and I want to thank all the audience for the questions. If you've got any last minute questions, please put them out now. But I want to encourage you guys to register now for our next Fiduciary Summit, which is on April 25th. There is going to be just a wonderful series of topics. Really looking forward to it. And I hope you can join us up in Overland Park, Kansas. Please register now for the event. We'd love to see you out there. There's going to be so many new topics, including reimagining your benefits and purposeful communications on women in finance. Again, more stuff on unpacking the Secure Act and a lot of fiduciary and participant breakout sessions, which were really, I think, a hit with for quite a few people last year. So you can always get such great stuff from your peers and the other employers out there. So again, I want to thank you all. There's, we've got our Fiduciary 15 probably coming up as well, which I don't think I see up here, but every month we do the Fiduciary 15, and Matthew's a big part of that. So don't be on the lookout for that in your email box as well. And I want to thank you all for joining us and taking the time out. I hope it was worth it. So thank you all.
Thanks, everybody.